Good evening, chat. Hello. Hope you guys are doing well today. And yeah, we got some, Russell Greer has given us the gift of hardship and the gift of a new lawsuit. And I'm looking forward to getting into this a little bit and talking about what Russell is up to at this point. Somali Daycare says, "Look at me. Look at me. I am the daycare now." Oh, yeah, and somebody's asking, "What about the hashtags?" You know what? YouTube apparently said I didn't do a good job with the hashtags last year, so that's part of the reason why the algorithm hurts a lot, so fucking hashtagging it. I don't know what else to do, so you're gonna have to suffer, fellas. Suffer. How can the governor of Ohio say fraud is the cost of doing business? Because Mike DeWine's a fucking scumbag little gremlin. He's a piece of shit. Mike DeWine is a turncoat Republican that actually is famous for voting for the assault weapons ban, among other things, back in 1994. So he's been a shitbag forever. Don't get too worried about him. Like, he's a turd through and through. So don't yeah. Don't let your heart not be troubled. Let me tell you. Let me tell you about that. Um let me see here. But yes, Russell is in the running for the law cows of the year here. And it's very interesting the way it's set up this year. It's very interesting the way it's set up on how this works. Where is? I wanted to bring it up because he's in the running for I believe he's in the running for emeritus this year. He's not law cow of the year material, but he's running for the law cow emeritus. And he's pretty good for that. And he should get his spot in the Hall of Fame. He should get a spot in the Hall of Fame. He's already won law cow emeritus, apparently. I haven't seen it yet. The ranked choice setup is really good. I agree. Yes, Noel has some pretty interesting ambitions in Ohio. Yes, he does, and he's talked about it. Yes, I floated out some information and some ideas that Noel is wanting to get involved in out there. Yeah, he's kind of working on it. He's kind of working on it right now. So yeah. But anyways, yes, I do want to say, if you guys were not aware, for the Law Cow Emeritus Awards here, we do have as of today, somebody counting the votes. We have Russell Greer. Russell Greer in first place. Congratulations, sir. Patrick Tomlinson in third. Then Nick Ricada, in third. Patrick Tomlinson second. So, good job. Good job, Russell. I applaud you on your victory. So, he should be up for the year. Yeah, but I think there's something to be said about not having him up there if he's your adversary. Like, because obviously going after the farms, he's always going to be a thing. I understand the idea of not necessarily giving him that kind of giving him that much power, because otherwise, yeah, then he becomes then it becomes like, oh, because he's in a lawsuit against us. And I understand that. I understand why Noel's doing it the way he's doing it. It makes sense to me. It makes sense. It makes, like I said, it doesn't have to make perfect sense to you. It's just got to make sense. I think it makes perfect sense to me why he's not doing that. I mean, it's obvious. And there's also there is a healthy stable of contenders this year, which I think is really important. I really think it's very important to acknowledge that there's a lot of stuff that's happened this past year. I really do. I think it's very important to acknowledge that. I think it's very, very important to acknowledge it. I don't know how else you can. But you have to, there have to be, You can't just keep hunting the same grounds over and over again. You must fish new waters, gentlemen. You must explore and conquer new lands and subjugate new lolcows. You know, it's manifest destiny. It's kind of how I look at it. Tipster 2026, believe him. Yeah, that, I guess that one also kind of is not a surprise, but holy shit. Turning out, I guess. Kirsha for Vet Alert. Yeah, Kirsha's in the running. I didn't realize that until I saw it. I was like, wow. I didn't realize there was like actually like a dox of her or anything. Is Kirsha all upset about this? I don't know. Oof, that sucks. Destiny didn't get it, which is fun. Yeah, but he got, yeah. Also, it's not me. It's not me. Thank you, though, good caps. Radcon says, I don't know if Kirsha reached out to you after a stream about Edwin Cruz Gomez who killed a 16-year-old for propositioning her. She's trying to figure out more of the court case, couldn't find anything. Yeah, no, I didn't. I don't think she, well, I don't know. Let me see. Did she DM me? She didn't reach out on Discord, so let me see. Is there a DM? No, but I'll reach out to her. Hold on, what's this guy's name? Edwin Cruz Gomez. He's an illegal from Honduras. Oh, he mowed down that girl in Queens. Yeah. Yeah. Oh, yeah. Here you go. Doing the jobs we won't do, chat. Killing girls that will not accept your sexual advances. He's doing the jobs that Russell won't kill women. So he's doing the job that Russell won't do. So, guys, without him, America would fall tomorrow. So, patrolling those thoughts. But thank you, Radcon, for $20. Thank you very much. I appreciate it. Yes. Can you hear the screaming? Oh, I don't know. Can you? Jelly Jerome, member for 4 months, is here for my dose of Greer GPT. Yes. Yes. Thank you for being here for 4 months. Yeah, this is going to be, we're going to get into the lawsuit he filed. Yeah, it's entirely ChatGPT done. I mean, I didn't have a chance. I'm not going to read through it and fact check up on some of the Nevada case law, but you can tell, obviously, Russell Greer didn't write this, but there's some little funnier parts in it as it goes. There are some other parts that are funny in it. Let's see here. After 2 days, anyone in the running for 2026 law count? I think Tipster will be. We'll see. Hassan, I know. Like I said, chat, I'm not going to tell you who I voted for. My votes are in. I did my votes. I don't wish to tamper with the voting. I don't wish to be a rigger, so I'm going to leave it alone. But I made my votes. Pirate Tomsky is a new member. Re-up. Thank you. Okay. So, your service is noted. Thank you. I have 2 accounts. I voted twice. I did not do that. I did not do that. I am not that big a shitbag. As a journalist, it's very unethical for you to vote. Well, it's awful. All right, guys. So let's get started. We were picking up with Russell Greer. You guys remember, this is Russell Greer versus the Farms. It's out in Utah for some reason. Still a mystery to everyone why it's still there, but Russell has been rolling like nat 100s. And you're like, but there's only 20 sides on a dice, Sean. Like, I'm not. I mean, I may look like I know that, but I don't care. He's basically just, he's unstoppable. He's been able to guard and protect himself for nearly 5 years now in this lawsuit, traveling to multiple courts. And this is a case of contributory copyright infringement. As we talked about a couple weeks ago with the Cox v. Sony case, this may not survive very long, this claim. But for right now, Russell Greer is claiming that no, let people put stuff on there and he contributed to the copyright infringement. Excuse me. I thought I was getting ready to sneeze and I couldn't. And when we left off, guys, we had left off at the part where Russell had filed a restraining order against Matthew Harden, and it failed. Tried to file a restraining order. It just wouldn't stick. It's kind of like everything in Russell's life. He couldn't stick the landing. And then Russell Greer tried to say, well, that's not true. And that's where we were on the 17th before Christmas. Things have kicked off since then. A couple more things have been filed. I think it's, this is the gift that keeps on giving. It's a gift that keeps on giving. Now, where are we at with this? Well, we are now on to the issues about Russell wanting to strike witnesses and improper noticing of the witnesses that are brought before him. Well, is that really what's happening here? Nah, not really. Not really. Remember, Harden's just notifying him, hey, we found all these hookers out in Nevada who say you're dangerous and a lunatic. They've read your book. It helps them give insight. There's criticism, commentary, all these things. And Russell's just about it. And has lost his mind. And he's trying to do improper witness disclosures. There's no formal process for it. It merely is, as an attorney, I notify the other party, hey, here's my list of witnesses that I believe may help support my case. Here's their information. Here's their phone numbers. Here's what I think they could show. Now, I don't have to give you a 25-page description for each witness, but I could say they could support this claim. They could support that claim. This person is background to the contract. This person knows about what happened after the contract was signed. This person saw it get signed. This person heard both parties state their intents in the contract. There's a bunch of different things you can have, like, for example, a contract. As you can tell, I'm using as an example. If there was a car accident, he was driving the car that saw it. This guy was walking down the street, saw it. He heard your client say something. He heard my client say something. This is the doctor who treated. Bop, 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 bop. And I just have to tell you what's going on there. I'm sure this will be a good cover. Anyone knows Sean will cover the Cyrex stuff happening? What's happened with Cyrex? I know, like, he had, like, what's happened? I haven't followed it in a while. So I generally only notice when something happens. Did he get arrested again? Or something? I don't know, GL, but let me know. If something has happened, oh boy, yes. Cyrex lives an hour away from me. Well, yeah, Cyrex got devoured by bedbugs or something. But yes, Russell Greer, or I'm sorry, not Russell Greer, Cyrex lives an hour away from me. So yes, if he ever had a court case, I would go down and watch it. Okay, so wow, I don't know where to start. No, he went to a mall to meet a catfish set up by them, and they fake abducted her with police reports. What? I'm gonna have to go read the thread because I am really confused right now. I'll go read the thread. I'll catch up on him. I drive by Cyrax at 2.0. It screams out the window, retarded. Yeah, that's what's gonna happen here. Would you take him in? Absolutely fucking not. I wouldn't let him set foot in my yard. I don't want all those bed bugs and fleas and whatever he's got in my house. I don't want any of that. I don't want any of that near my neighbors. The HOA will get mad at us if we were to do that. That would be awful. I don't want that at all. Oh no, chat. You guys have your priorities mixed up here. Holy shit, you guys just went all crazy here for a second. Jelly Jerome for 10 subs. EDW Raptor for 10 subs. I mean, you guys get a Kleido for all that. It sucks I can't get him to a woo in person again, but we caught lightning in a bottle there. Pirate Tomsky for 5 subs. C3 for 5 subs. Good to see you. It's been a little while. Hope you're doing well. For 10 subs. Stephen Cooper for 5 subs. Holy shit, you guys are going crazy. And remember, chat, that's what happens when you donate to the Greens and you help make America green again. You keep America green, you make it green again, we pray the gray away. That's what you're doing to those subs. That's what you're doing to the grays. I mean, and really, it's this too.
You see this? That means not welcome.
That's right. No sepia tones or grays allowed. Keep walking. Jim tells you it's been a member for 22 months. Thanks, Jim, for being here. I appreciate the support. Says Happy New Year, buddy. Well, Happy New Year to you too. Should join me sometime. I'll reach out to you about that. But thank you for being here. Thanks for the support. All right, I think we're kind of caught up here. Oh, we got No for 5,000 Argentine pesos. Hell yeah. Hell yeah. Right there, guys.
Was this story based? Yes.
Absolutely based here. It says, hell yeah, it's Greer time. Enjoy this 338 in US. As is a physical maximum, you two allow me to super chat you. Well, thank you very much. I appreciate it. Just started law school. Well, congrats. I assume you guys have a, well, is it, are you guys aren't Napoleonic, are you? Like a civil system? Going for that second degree. Well, good luck, man. Good luck. I don't know whatever advice I can give you, but if you ever have legal U.S. questions that you need for stuff, let me know. Be happy to answer them. Just shoot me an email. There's a surprising amount of similarities between civil law and common law. There are, but I still think common law at the end of the day is still much preferred. And you kind of, I guess you do have civil law there. So, well, thank you. Thank you for being here. I appreciate it. Thanks for the super chat. Thank you. Thank you, guys. Let's go. Afuera! Let me see here. Let's 5,000 snow pesos. Yeah. They are, guys. There's nothing wrong with those. It's what YouTube allows. You know what? EW Raptor's right. It's a red boy. A red boy is a red bomb is a red bomb. It is. Let me see here. What did I... Oh, I just missed the chat. Sorry, I was trying to go back through and click on stuff here. I hate this. It keeps fucking moving. There we go. All right, we're going to keep going here. All right. So what did Russell Greer do? Well, his motion is to strike and exclude improper witnesses. Disclosures to Roger Blaylock. Guys, remember, Roger Blaylock is the... That's such a weird way to spell it. Roger Blaylock is the owner of the Shady Side Motel or whatever the hell it's called. This is that motel Russell Greer wanted to eminent domain in order to turn into a whorehouse in Winnemucca. And this is the one where his buddy, Waylon Huber, is apparently like the Section 8 housing manager for the city of Winnemucca. It was going to help try to finagle a way to get the government to take this guy's land from him, so Russell could do his whorehouses. Remember, this is the funny thing. This is all about Russell wanting to have a whorehouse. That's the crazy part. It's all about Russell and fucking hookers. That's all this is Russell Greer and his desire to have hookers. You know, by God, he will have his home again. Through drool and kvetch, he'll get there yet. Oh my God. If you guys get the Manor Boone song, by God, he will have his home again, let me tell you. But he never had it to start with, but so that's Roger Blaylock here. And remember, we're now into the Chat GPT phase of Russell Greer. And notice still, this is garbage. The spacing's garbage. Can we do justified alignment? Can we do something here? And Anyways, Russell Greer respectfully moved his court to strike the defendant's December 20th purported witness disclosure concerning Roger Blaylock. Now, if you notice, he's saying this here, but there is no filing for the 20th here in regards to that. This is the way this works is this is all done privately. This is all done by, it's not done privately, I guess, Chad, I would say. It's done by email notification. Like, it's done by correspondence. Before email, you would fax or send letters to each party. Here's who I have, here's who I don't have. This idea that Russell, like he's, motions to strike are things that affect the actual record. So if you're striking something, you're striking like, you'd be striking motion 424. You'd be striking this. You'd be striking that. You don't strike private, correspondence between parties. So this is already just an issue here. This is already just an issue. At this point. So they talk about, they want to get rid of the disclosure concerning Roger Blaylock, a private non-party. Well, yeah, if they were a party, you wouldn't have to give notice of them because it's presumed you have noticed that your party could be called as a witness. With no relevant knowledge or any claim to any defense in this action. How do you know, Russell? How do you know? The disclosure is irrelevant, immaterial, and prejudicial was made outside authorized discovery. No, it's not. You're allowed to keep providing discovery. You just, all the discovery timelines are paused. And getting stuff said in will be paused. But this idea that otherwise, it doesn't work this way, Russell. So it was made outside authorized discovery. It appears calculated to harass and intimidate rather to advance any legitimate litigation purpose. This fails to comply with disclosure with Fed Rule 26A1A1, which violates rules 12F, G, 26G, and 37C. It should be excluded in full. Well, what is he getting at here? Let's go take a look. Here. What is it? What is Rule 26? So we go to FRCP Rule 26. Or Rules of Procedure Rule 26. A1. A1. A little 1. Or Roman numeral 1 here. I'm not sure. So we go to Rule 26. So we're here. Okay, we got A1. Okay, A and 1. All right. Well, so this is right off the bat. It's easy enough. We found it, isn't it, chat? A1 sounds like steak sauce. But here's what it says. What does A1A say? What do you have to do? The court, or as otherwise stipulated, a party must, without awaiting a discovery request, provide to the other party. So we're already going ahead and doing it. The name, and if known, the address and telephone number of each individual likely to have discoverable information. Along with the subjects of that information, the disclosing party may use to support his claims or defenses unless the use would be solely for impeachment. And remember, you don't have to disclose impeachment information. So because the presumption is your witnesses are supposed to tell the truth. Your parties are supposed to tell the truth. I don't have to disclose that. You have to go forward with it as is. Now, if your party is not telling the truth, I'm allowed to impeach them and do anything here. So Matthew Hardin said, I intend to call Roger Blaylock. Here's what he can talk about. Here's what we can talk about. Okay. So what did he do here, Russell? Tag on news says, that's not true. It's not true. Oh, so here's how we go. Here's how we're going to get back to this. So it's saying Russell's disclosure identifies no testimony by Mr. Blaylock relevant to copyright ownership. Ownership, infringement, access, substantial similarity, defenses, or damages. Instead, it attempts to inject the plaintiff's unrelated real estate disclosures, meaning Russell's lies, his speculative commentary about finances and business plans, once again, his lies, a personal narrative wholly divorced from copyright law, your credibility and your lies. So yes, it all goes for that. It goes all for that. Oh, it's Baylock. I'm sorry. I keep saying Blaylock. Yes, Baylock. I'm sorry. It's Baylock. I'm sorry, Chad. I can't even. These disclosures must be narrowly tethered to actual claims and defenses. They cannot be used as a vehicle to smear a litigant, intimidate citizens, or insert collateral material into a docket. True. True. Notice he doesn't have like a Ninth Circuit decision here, which is a little weird. Just a little weird here. So it says the initial disclosures may include only individuals likely to have discoverable information. Yeah. That a disclosing party may use to support its claims or defenses. And it says, also, don't use widows or orphans, Russell. Control Enter. Move on. Keep moving from here. Control Enter. Courts may strike any redundant, immaterial, impertinent, or scandalous matter. Yep, that's not, Russell, that's not Rule 12. Like, we're not, like, Rule 12 allows you to do that, but that's not what Rule 12, like, you're in the wrong spot here, man. You are in the wrong spot because Rule 12 is for pleadings, defenses, and objections. So Rule 12F is about striking a pleading is insufficient. It's not about striking a disclosure. So Rule 12F is not applicable because it's all about striking a pleading. And that's not where we're at. Russell likes the word tethered. It's AI using that. That's where we are here. So let's get back to this. Rule 37C. A party that fails to comply with Rule 26 may not use a witness unless the failure was substantially justified or harmless. Which is really funny because it's like, guess who had that problem here? His name is Russell Greer. I'm just saying, because he already can't introduce any witnesses. Oh. Cecilia's saying there isn't a procedure for striking a disclosure, is there? I mean, there is a... If somebody's breaking the rules, you could always move for sanctions and protective orders and protective action. You can't just say strike it. Well, if they're breaking the rules and they're doing something wrong, file a motion for sanctions. Like, you can get sanctioned for this conduct. That's not a problem. That's not a problem at all. So they say Rule 26G, disclosures intended for improper purpose warrant corrective action, which you can get depending on how this goes here. Yeah, and this is the thing, David. You can only strike all this once it becomes something the court has to deal with. But in the meantime, if you think somebody's breaking the rules, you can always move for sanctions. You can always move for a protective order. Those are always available to you as a party. File one if you think you need one. And if you're not sure, talk to your attorney. If you're not working with an attorney, buddy, that's kind of why attorneys exist. So that's why you don't work. It's why you don't work with your own. That's why you don't do stuff on your own. It says Roger Blaylock has no relevant knowledge of copyright. So he's saying here that it's all about efforts to acquire or lease property, financial resources, or business reputation. All this is about Russell having hoes and hookers. They're saying Mr. Baylock has no knowledge of any copyrighted works, access to those works, copying or distribution, similarity, fair use, or damages. How do we know? How do we know? We don't know that, Russell. We don't know what you know. We don't know what you know at this point. There is no information here. There's no way for us to know what's going on. It doesn't make any sense. I just don't understand what you think this does for you here. It doesn't. It doesn't really do anything. Courts routinely strike witnesses whose knowledge is not mapped onto the elements of the claims asserted. Okay, well, labeling the unrelated personal knowledge as witness testimony does not create relevance. And then he goes on, another orphan, quit doing orphans. Don't do orphans, chat. Orphans are bad. Control Enter onto the next page. Discovering this matter is stayed. No subpoena has issued. Okay, but that's it. He still is going to notify if he's doing due diligence. No more orphans, please. Yes. Hit those orphans like they're in a Ukrainian orphanage. No court authorizes informal third party to. No court order does disclosure. The court has already told you, Russell, he's allowed to do this if you've not gotten the hint so far. The court has not stopped it. A unilateral email declaration does not satisfy Rule 26 and doesn't convert irrelevant information to admissible evidence. Yeah, it is. An email. Here's who I'm using. Here's who I intend to use. Not everything gets filed. Not everything gets filed, Russell, like that. You know, the publication of Baylock's personal information serves no litigation purposes. The disclosure republishes Baylock's identifying and contact information, despite his status as a private citizen with no role. It's not being published. Where is it? There's nothing here regarding a witness, Russell. There's nothing here regarding a witness. I mean, if you publish the emails that have it, you would be doing that. Now, here's the thing. This information is unnecessary at this stage. If you didn't get the emails and the phone numbers and the contact information, you'd be squealing like a stuck pig that wasn't being provided to you, Russell. You don't get to have it both ways. That's, you know, this idea that it's special here, like, come on now, Russell. You'd be screaming and crying if you didn't get this information. Now you don't get to cry that you're getting the information. The filing is scandalous and impertinent. Those are $20 for Russell. Those are $20 words. It's outrageous. It's like my one law professor said. It's outrageous. Oh yes, it's scandalous. Like on I think it was the show Recess. They're like, "Ooh, it's scandalous." That's how the girls would say it. The narrative insinuations regarding his finances, business aspirations, meaning he wants to run his whorehouse, or unrelated conduct, meaning his whorehouse, and they have no nexus to copyright. Material that lacks probative value and risk collateral harm should be removed. It's not removed from the docket. There's nothing on the docket, Russell. There's nothing on the docket. Improper disclosures have resulted in foreseeable third-party harassment. The repeated practice of publicly designating uninvolved parties as witnesses has resulted in tangible harm. Shortly after the 2025 December 20th disclosure concerning Baylock, a third party connected to plaintiff was subjected to anonymous harassment communications, echoing the same stigmatizing themes previously injected into the extrajudicial disclosures. Okay. And then here we go, though. Plaintiff does not allege coordination between the counsel and the anonymous actors. Then what's the problem? People are doing something. Come on. Oh, come on. Oh, but yes, once again, remember, guys, there has been no disclosure. The disclosure was entirely between the parties to Russell. Remember, guys, there is no disclosure on here. There is no disclosure on here. Absolutely ridiculous. Absolutely ridiculous. Say, however, there's only harassment as a foreseeable consequence of publishing identifying information and accusatory narratives about private citizens with no relevance to the case. I'm sure finding Roger Baylock at the Shady Side Motel in Winnemucca, Nevada wasn't that hard to do, Russell. It's pretty obvious. It's like, we're not, looking for John Smith in Utah. Federal rules exist to present precisely this type of harm. And it says, we're litigation tactics and, hammer parties. They say here, the conduct is across from improper disclosure to conduct that risk transforming civil litigation into a vehicle for third-party harassment. When you're saying at risk, you're not saying it is. So which is it? The latest closure is retaliatory. They point out the witness disclosure further underscores its improper and retaliatory nature. In his December 20th email, defense counsel justified the disclosure of Baylock by asserting his scope of knowledge includes Russell's alleged financial representations and the content of documents referred to by Greer in pleadings before the Las Vegas Justice Court. Yeah, we'll find out that you're lying, Russell. We'll find out that you're an ass. we'll find out all kinds of things to use against you. He says, this assertion is telling. Yes, we know you're an asshole. We know you're a scumbag. The proceedings in Las Vegas court, including plaintiff's efforts to seek protective relief, have no bearing on any claim or defense in this federal copyright action. But they do. They do. There's a reason why you ran away to a different court, Russell. There's a reason why you ran away to a different court. Because also remember, guys, when we went over Russell's protection order, what did he cite as the reason? The entire court case here and only here. So you're saying it doesn't matter. It has no bearing. When yet it was entirely related to this. And without this lawsuit, you wouldn't have gone for that. As said, that's telling, Russell. It's telling. By expressly invoking filings with unrelated court jurisdiction, defense counsel confirms the disclosure is not driven by evidentiary necessity, but by collateral disputes arising from plaintiff's pursuit of protection from extrajudicial conduct, which you cited back to this case, Russell. The timing reinforces this conclusion. The disclosure followed closely on the heels of plaintiff's protective filings was accompanied by the publication of a private individual's identifying information. Despite that lack of relevance, courts routinely reject this type of attempt to leverage discovery. And it said, viewed in context, the reference to justice court filings confirmed the disclosure was not made in defense of this action, but to import collateral matters. You're the one who went out and introduced a new collateral matter, Russell. And then once again, another orphan. Like, just control enter, please. For the love of God, Russell. This is also your margins. Like, what kind of margins are you running? I didn't think about this before, but like, you're running decent margins everywhere else. But when you get to the bottom, I mean, even here, that's kind of a big margin. That's like an inch plus. But down here, man, what kind of margins are you running? Because like down here, there's a big margin. But right here, it's like a little itty bitty baby margin. Like, what are you doing? Please work on this. Please work on this, Russell. Format it for the love of God. Format it for the love of God. Please. The disclosure is not an isolated error. It's a documented pattern of counsel pursuing collateral non-copyright narratives. So what does he want? They want to strike the disclosures. There's nothing to strike, Russell. It's not on the record. Prohibit the defendants from naming Baylock as a witness. That's going to be something you'll have to do a motion to quash. Direct defendants to refrain from publishing personal or retaliatory material concerning parties. They haven't published it. It was provided to you privately. And yes, David, I've heard. We're still not sure he has an actual computer or not where you can actually see things on the screen. To be fair, though, like on my phone, when like if you're using Microsoft Word, like I've had to sit in a parking lot before of a courthouse or sit in the lobby of a courthouse. Like, you know, the court's like, can you put together an order right now? Just a generic order. I'm like, you can't do it. Like, yes, sure, Judge, I'll do it. Yes, of course, Your Honor. You go out in the hallway and you just boop, 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 boop. And you sit there with Microsoft Word open up. You can click print preview in like a print mode so you can see what it looks like. And then you just send it as a PDF. So this idea, I don't know what's going on where he can't see it. And you'd think he would go to a hospital. Not a hospital. Wow, that was dumb. He could go to a library. I know he's not banned from those. You could go to a library and do work. But at least format your stuff. This is just... He's going to a hostel. Oh my God, that would be scary for him. That would be scary for Russell. Oh. They want an order for the defendants to refrain from disclosing identifying information of non-parties. Another relief. Sign Russell Greer. Russell Greer. How can I type on Word while it's eating sandwiches? Because I only, nom nom nom. I can, look at me, chat. Look at me, chat. Multitasking. Nom 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 nom. I can do it all at once. Warming over the next phone. What is this? Are we getting a weather alert? Uh-oh. Uh-oh, chat. What's going on in the... Ooh, it's going to get warmer tomorrow. Thank God. Ooh, we're going to get more snow tomorrow. Jeez. And then Sunday, we're getting snow like all frickin' day. Dang, man. Yes, all one-handed, chat. One-handed. Shilling Microsoft Office again. Yes. Microsoft Outlook is a great email platform. Microsoft Word is, I don't know why people use anything else. And then if you ever need to, Excel is always good. And then OneNote is, if you're in college or you're in school, OneNote is God tier for note making. So I don't know what you want me to say. He could have been banned from the library for attacking the librarians. That'd be funny. Oh, no. Oh, no. All right, but anyways, here is the certificate of service. Here's the exhibit. And this is where, hold on, chat. Yeah, okay. So Russell took care of this. Russell already took care of this. Good. So this is an email that Matthew Hart had sent to Russell Greer saying, here's what, your refusal to provide the documents relating to Roger Baylock, which you previously indicated were highly relevant, you'd be happy to provide upon request. Now, here's the problem. This is, Russell's probably already said he'd provide those. So Matthew Hart had to go out and do it. Guess what? This was not public till you. I don't know what his information is. It's still not out there, Russell. Nobody has it. None of us have it right now. So, yeah, like this isn't a problem yet, Russell. This isn't a problem. You're screaming and crying about nothing. You're screaming and crying about nothing, Russell. There's nothing else to do here. There's nothing else to do here. So, another thing Russell files, this is right afterwards. Well, that's a problem. Yeah, when Russell went to the library, he's like, are you like the librarians in the porn commercial? Or the porn? And he's like, no. And he gets all mad because he's like, but on the internet. But on the internet, though, it's something else. It's like, yes, Russell, it's always something else, man. That's not how that works. And then there's also this, I think it's just funny with the meme here. Hold on here. There's a very funny, there's a YouTube short. I forget where it's somewhere on here on YouTube where the kid has a stepmom and the stepmom's like, well, hey, your dad went out of town. What do you want to do today? And the guy's like, and he's like, no, I don't want to do anything with you, stepmom. And she's like, can you help me? He's like, I'm not helping you at all. And it's very, I wish I could find it because it's so fucking funny. It's so damn funny. Hold on, maybe it's, where is it? Yeah, I can't find it right now. Damn, that sucks. There's no, yeah, it's gone. I can't find it. It's actually fucking hilarious. It's very, very funny. So I guess we won't have it today. Was it Trevor Wallace or someone like that? Maybe. Yeah, what are you doing, step lawyer? Actually, it might be Trevor Wallace. Hold on here. Yeah. Let me see. No, I don't think so. I don't think it's him, which sucks because it was really funny. It was really funny when I saw it. Yeah, no, hold on. Shaz is double checking. No, I can't find it. So we're not going to worry about it. We're not worrying about it today, chat. We're not worrying about it. We'll keep moving with Russell Greer. That's what you do to your real mom? Thanks, Bob. I guess we get lonely down in Australia. Yes, help! I'm stuck in a lawsuit. I can't get out. All Right. So now Russell is for real. He's moving for sanctions under Rule 37. He's like, I'm not joking around. So what did he want to do? He wants to move for sanctions based on the repeated failure to comply with Rule 26 and continued misuse of witness disclosure. So he figured it out. This is how you go after things. You don't strike it, you do a sanction. Yes, it do be like that, Mr. Martin. This plaintiff's first motion for sanctions brought only after the defendants have now made 3 separate disclosures, each untethered to copyright, each requiring plaintiff to take time out of his day to strike the disclosures. There's nothing to strike, Russell. There are now on 3 occasions designated private noun parties as witnesses. In response, Russell filed motions to strike the improper disclosures to prevent prejudice and collateral harm. That's not, you wasted time here. Despite those filings, it's happened again. Only after the 3rd irrelevant disclosure did plaintiff seek sanctions under Rule 37C1. And it says, Rule 37 provides where a party fails to comply with Rule 26, the party is not allowed to use that witness or witness to supply evidence unless the failure was substantially justified. Now, he says here the conduct reflects noncompliance. Each is a party with no nexus to copyright law. How do you know, Russell? How do you know? Are we going to see? I don't know if we're going to see anything before 2050. I bet we're going to be at like pleading number 500 before freaking St. Patrick's Day at this rate. Actually, chat, mark it down. That's my lock of the week. Pleading 500 by St. Patrick's Day. God, we'll probably be at 600 by then. Each replied to speculative collateral scope of knowledge untethered to the pleadings. Each published identifying information without necessity or court authorization. Aside from the Natalie Banks disclosure, you can tell this really gets Russell fired up. Really fired up. He's all fired up about Natalie Banks. It's like, you sit for Natalie Banks! That bitch! Without identifying information was lacking and was filled with libel and smears, and each required plaintiff to file a motion to strike. That wasn't necessary. This repetition establishes a pattern. Well, as an autistic person, Russell, you probably do like patterns. There's no substantial justification. The defendants cannot claim confusion regarding the limits on disclosure. The most recent relies on filings from a Las Vegas Justice Court matter, confirming the designation was driven by retaliation. No, it's because you introduced it to the case, Russell. They're allowed to do it. They're allowed to do it. Confirming that, this is what you did, Russell. Disclosures have resulted in actual and foreseeable harm. When Matthew Hardin made the disclosures, it appears he scrawled the web for the 2 Winnemucca individuals and then sent the disclosure to Greer through email. That email was then published to Kiwi Farms. The insane persons on that website, in turn, began to if it's published to the farms, Russell, how do you strike something that's published publicly? You can't strike it. It's public information. So once again, you're using words you don't understand. Yes. Patterns. Choo-choo. The insane persons on the website, in turn, began targeting the disclosed persons because that's what those incredibly sick users do for fun. And people who like to look into things, Russell. On December 20th, the presumed Kiwi Farms user, it's presumed because it fits the sensational pattern these individuals contacting people close to plaintiff and exaggerating the plaintiff's background, going by the name Ajax. Maybe he was just a Greek warrior who, dares sullying a veteran of the Trojan War. One of Achilles' Myrmidons. One of the elite troops that Agamemnon used at Troy. How dare you, Russell? How dare you besmirch that name? Anyway, he CC'd defendants previously disclosed witnesses and began telling this person and others false allegations about the plaintiff. The email was incredibly bizarre, and it seems like Ajax is mentally ill. How do you know, Russell? From my own personal experiences. Ajax sent more emails. This resulted in contact with law enforcement by plaintiff and at least one affected party. You know you're going to have to provide that information now, Russell. This is going to be interesting. You're going to have to provide this. Plaintiff strongly believes Ajax was emboldened by the disclosures meant to protect this type of information. And we don't have the, and as Cecilia is right, we don't have the emails from Ajax. We don't. So, the prior court enforcement the need for sanctions. The court demonstrated it takes disclosure obligations seriously. In January, the plaintiff of 2025, the plaintiff was sanctioned. Remember, Chad, it was just like it was yesterday. You know, where has the time gone? Really, it did seem like it was yesterday. Plaintiff was sanctioned for initial disclosure errors. It wasn't an error, Russell, in order to pay monetary damages in the amount of $1,275. Defendant's present conduct stands in stark contrast. Despite the court's prior enforcement of Rule 26, defendants act as though they taunt the rule. They're acting as though they taunt the rule, Russell, or they do taunt the rule. This is the problem. ChatGPT gets too flowery in its writing. Am I flaunting the rule, or am I acting like I'm flaunting the rule? Because one is wrong and one is not. Defendants have persisted engaging in more harmful practices, naming irrelevant private individuals, publishing information, listing the relevant information as matters unrelating and irrelevant to the case. This conduct warrants sanctions and deter further abuse. To not sanction defendants over this conduct will leave the impression of bias. Okay, Russell, you have to disclose exactly who is who and lay it all out. Like, who was the first one? The first one was Waylon Huber. You need to list all of this out, Russell, and you haven't done that yet. You haven't done any of this. Haven't done any of this. The defendant's conduct imposed substantial and unnecessary burdens on plaintiff. Chad, it's the hardship. It's the hardship. Agent proper disclosure required time-consuming motions to strike, but they didn't. It required just this, a sanctions motion. It required dealing with third-party harassment, such as from Ajax. They say monetary sanctions compensate a party. Excluding these irrelevant persons alone is insufficient, where non-compliance is repeated and harmful. Plaintiff is prepared to submit a concise declaration itemizing the time expended solely on corrective motion practice. You should be submitting that anyway. And the alternative, non-monetary sanctions are appropriate. Should the court decline to award fees, they request non-monetary sanctions, including a formal reprimand or admonition of counsel. Okay. Why aren't you asking for disqualification of counsel, Russell? You've already asked for disqualifying counsel. Are you now backtracking from that? If I'm Matthew Harden, and remember, Chad, I haven't read the filings yet. I'm kind of going to this one cold. I spent the past 2 weeks staying away from this. Are you now saying that you don't want him removed from the case? It doesn't work. This don't make no sense. And prospective limitations on non-party disclosures absent court authorization. Such relief is appropriate, except it's not. So what do they want? Prohibit defendants from designating non-party individuals. In ordering barring publication of non-party identifying information, such as on the Kiwi Farms, outside of formal discovery. You notice, Russell, you haven't included as an exhibit or anything. Things from the farms, like here's this post, blah, 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 blah. So you actually have not provided any proof. Award reasonable fees and costs or an alternative to the imposition of things, including a formal reprimand or an admonition of counsel, which are literally nothing. I thought you wanted him gone. Signed once again, Russell Greer. There. Actually, there you go, Russell. That's a free. You can use that as your signature. That's actually pretty good. That's a pretty solid signature right there. Use that. Use that, Russell. I help you out. I'll help you out, buddy. But there's nothing added to this. So how do I know what to do? How do I know what to do, chat? I don't, chat. It doesn't help me here. It doesn't help me. Stylish signature right there. It is. It's a flourishing signature. John Hancock, eat your heart out. So Matthew Harden, being the adult here, comes in and has to file a motion in opposition to the motion disqualifying. And remember, Matthew Harden has to catch up on these. He's got to catch up to Russell because Russell gets to run around the world. Remember, A lie gets halfway around the world before the truth can even put its pants on. Which means, does that mean lies don't have pants? Well, if their pants are on fire, maybe not. Maybe not. So what's happening here? The defendant sought various forms of relief, including extension to oppose the Russell Greer's motion. Because the court has not ruled on those and the current deadline expires today, the defendants filed this opposition solely to protect their rights and ensure time for them to file. A response does not elapse. And this is actually what you do if you're not sure. I'm filing a basic opposition on all points just to make sure I don't lose the opportunity. Instead of doing what Russell does, where Russell Greer just sits there and goes, just twiddling your thumbs. Ooh. Oh, I didn't know I couldn't do anything. No. Until you're told you have to, it's what I tell my clients. Hey, did we get, I tell them, hey, I'm going to be seeking, the clients are like, hey, can we get continuance? Until I tell you court has been continued, your ass better be there at the date and time. And that is the way you do this. Until this happens, until you get it, you have to operate as though it has not been granted. So they assert that Greer has shown no legally cognizable misconduct or grounds for disqualification. Instead, the entire premise to be the defense is not allowed to investigate his claims or his potential fraud on this court. But there is nothing improper about defense investigating Russell Greer's dubious claims. In fact, it would be malpractice if our side counsel did not investigate all available defenses. Yes. And if one of the defenses is to show you lied about IFP and the case dies right there, and the case becomes dead as Dillinger, why would he not do that? That is the way you do it. Yes. And as Embalmed says, yes, I demand that you don't defend yourself. It's like, well, that's not how that works. That is not how that works. That is not how it works. And it says the court were to find somehow that it can be construed in a manner that would support disqualification. They request the court identify any basis and issue a show cause, which would allow defendants proper notice and an opportunity to address any concerns, which also would allow for a hearing, presumably. So they argue, once again, this is just an improper effort to pile on Russell Greer's numerous unsuccessful efforts to prevent defense from continuing its ongoing investigation regarding Russell's informal pauperis status. All these ECF filings, oh my God, that's a lot. So they're asking, Judge, just leave us time if you do decide to do anything, which we know you won't. So that's Matthew Hardin here. Just very simple, very stated, very well done. I like it. Very fancy. And then from here, we now move on to the spreading of hardship, the spreading of Russell Greerness being Russell Greerness. This is where it gets fun, chat. This is where it gets fun. This is a notice of supplemental authority, meaning there's other information out there to make the court aware of. And here it states that the defendant sought sanctions on June 5th, arguing that Greer engaged in a flagrant violation of the court's stay on discovery. In opposition, Greer said he didn't violate the stay or he believed his behavior was justified. They say in parallel litigation, Greer later told the Las Vegas Justice Court under penalty of perjury that he had violated the court's discovery stay. And this is the problem. Everything you say can and will be used against you. He says, I attempted to pursue formal discovery through 2 subpoenas. That says, thus, there is no longer any question of whether Greer acted willfully or with knowledge that he was violating the court's discovery stay. Greer has now admitted his own words voluntarily and under the penalty of perjury. Monster kill. Ludicrous kill. Godlike. Holy shit. Unstoppable. I wish I could do it right. But yes, now is the court going to react on any of this? No. He's going to guard his way through it. On December 23rd, Russell Greer filed a new lawsuit in Nevada, and that lawsuit Greer told the district court he has training and experience as a paralegal and is therefore familiar with research, drafting, and procedure. Greer also added that as a result of his training, he is fully capable of representing himself. Defendants submit that Greer's self-professed knowledge when dealing with this undermines his purported sincere belief defense in this court. It also shows Greer's legal violations were willful in nature and makes sanctions more appropriate. Yes, and how do we know all this? Well, because we have this here, and there's a problem here with this filing already for Russell. Russell is filing this in the District Court of Nevada, so federal court again. Here's the problem, chat. It's Russell Greer, care of a Safer Nevada Political Action Committee. Russell Greer could sue on his own behalf. He cannot sue on behalf of a corporation. He cannot represent a corporation. He cannot represent any sort of political entity at all. You're not allowed to do that. If you own a business, you can't sue on behalf of your business. Now, for example, if you run a lolcow milking parlor, you cannot sue on behalf of the parlor or the LLC that you're formulated under. You could sue in your own individual capacity, but you're not allowed to sue like that. You can't represent a non-person. You can only represent yourself. Horrible is saying, is he trying to hide his address with that care of? Well, he has a P.O. box, and I covered that up because Russell's going to juice his tampons probably anyway, so I hide the whole thing anyway because Russell likes to cry, and, for some reason, Russell thinks, I'm a big meanie, I'm a big hardship too. So right here, Russell can't represent a Safer Nevada. Although and that's the thing here. He also says pro se litigant, and then L. First foreshadowing, chat. I don't, this lawsuit, it's a foreshadowing. It's a foreshadowing. It's an L. It's a loss, Russell. It's an L. L. Oh, so it's a complaint for declaratory and injunctive relief. Now, here we go. It says Russell Greer, an individual, but it says care of a Safer Nevada, which is a little like, who are you representing here? So anyway, how does this work here? So Russell's suing, and we're not going to get into the weeds on this because it's interesting what he's arguing about. He says Nevada has a burdensome requirement that 5 qualified electors of a city or county sponsor local ballot initiative petitions before circulation may begin. Whereas only one person may initiate a statewide petition. Well, yeah, how dare people, you need support of a community before what's the problem? If you can't find 5 people and win a mucka, Russell, that want you to build a whorehouse, I mean, maybe that's a problem for you. I can't find 5 people in Nevada who want to be my neighbor and want to live next to my, my futuristic, groundbreaking whorehouse. Like, that's a bit of an issue there for you, Russell. That's a bit of an issue there, buddy. That's a bit of an issue. He says this disparate treatment violates the First and 14th Amendments. I mean, it's an interesting claim to try to make to the U.S. Constitution, Article 19 of the Nevada Constitution. Yeah, I don't know about that. Is this an as-applied constitutional challenge? I mean, maybe it might be as applied, but we'll see here. We're not really going to get into this. So it's a First Amendment that's too minor to dismiss. I think it's not going to go anywhere. He says plaintiff does not challenge the remaining procedural requirements governing initiative petitions, but wants to limit the 5-person requirement as applied to the initiation of city and county petitions. That means he can't, wherever he's trying this, he can't find 5 people that want to support him. Think about how big of a goober you have to be. Think about how big of a goober. Not even a bad person, just so annoying or such a goober and a weirdo. You can't get 5 people and these desert towns of like a couple hundred, maybe. You know, think about it. Think about it. Think about it's like Tremors. You can't get Bert and Walter and Val to support your thing, like to support your initiatives. Like, I get it then when you're in like, isn't it Paradise, Nevada? Or what is it? What is the name of that town in Tremors? No, Perfection, Nevada. Perfection, Nevada. Like, I get it. If you're in Perfection and it's population like 6, okay. But your county has more people. Yeah. People could sign a petition just to get rid of him. That would be hilarious. I guarantee it. You could probably get a petition just to kick Russell out of their county. Isn't Paradise a town in Postal 2? Yes, it is. Yes, it is. I am sorry, chat. I messed that up. Not even Bert would support Russell Greer. Oh, he wouldn't. Bert's a very wholesome man. He would not be supporting a whorehouse, even though he's probably very libertarian. So, you know, they got their petitions. They're not coming with you, dear Russell. Get the fuck out. Oh God, everything you could tie to. You could tie everything to that song. Bert would lose his mind over the eminent domain bit. Oh, 100% he would. He respects expedited resolution of this matter by early March 26, so that signature gathering may begin to qualify for the November 26th general election ballot. Oh, this is just so funny here. So the venue's proper. We're not worried about venue. I'm sure that's correct. So here's the issue. Russell says he's a resident and he's the founder of A Safer Nevada. The PAC's goals are to expand prostitution legally throughout ballot initiatives. Once again, Russell, this is like your time. You said you're an individual here, but you're like also doing this. And I don't know. I'm sure the state of Nevada is going to be like, this don't make no sense. There's the defendant, Cisco Aguilar. You know, is that the Cisco? Like, well, he's got that Cisco had a Q, but like the dong. Got the dong song, Cisco. Well, anyways, he's suing on here. He goes for a couple pages. We're not reading all this chat, blah, 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 blah. Signed Russell Greer. And it says, note. What? And I don't understand why you hadn't included this here, Russell. This is all vanity, which is great for a lol cow. But this is totally what Russell would do here. Totally what Russell will do. Yes. It's Cisco. Yes. I remember that guy. Yeah, well, that's funny because Somali, when you think about it, you know, that part of the song, having dumps like a truck. You know, kids nowadays think like having a dumpy or a dump truck and all that. Like, that's old. That's boomer talk. It's like when they have that phrase, it's like, I was around when people said it. I was your age. But yes, this is all self-glossing and self-filleting here for him. He has training experience as a paralegal, is therefore familiar with legal research, drafting, and procedure. I don't know about that based on what you've done so far. He's fully capable of presenting himself and brings this action in good faith. This will be used against you for now until the end of fucking time, Russell. Have fun with that. Have fun with that. Have fun with that. Have fun. Have fun. But now you're never going to be able to target guard again, Russell. That's not going to work. It's not going to work for you going forward. It's not going to work at all. And hold on here. I need to get where is he? And from here, guys, there is he's filing a pro se here. Here is the interesting thing. I was around when meme songs were just songs. You're damn right, man. Here's the interesting thing. This is interesting. And I'm sure this is going to be something that burns Russell later. This is how the District of Nevada, and chat. Uh-oh. So this came out a couple days ago. And Russell did not pay the filing fee for this case or file an application to see an informer Pop Harris. Okay, so Russell must complete an application to proceed IFP, or if he can pay it, he must do so. So by January 22nd, 2026, and I think Russell took advantage of the fact he probably doesn't have money, but he will have money at some point. I think this is Russell's goal is to go ahead and do this. But he's kind of spacing it out. I'm sure he's basically kiting complaints. So Russell has not paid, but he's going to have to pay. And notice he's basically got 20 days to pay up for the 405 fees for civil action. So I don't know what Russell's going to do here. And yeah, he asked for the IFP forms, but if he does that, then it becomes an issue because that court should become aware that Russell already paid for other lawsuits. So this is kind of where Russell's getting caught. His desire to have hookers is catching up to him and is causing him problems. Yes. Can he reach the goal, chat? I don't know if he can. And hi, Hella. Is Russell Greer my Lauren? Kind of. Hope you're doing well out there, Hella. So that is where things are going here. Russell is causing a lot of problems here, and I don't know how he thinks is going to help him. I really don't know how he thinks is going to help him. All right, so we got to catch up on some other things here real quick. Alert One System says sepia tones, lol. No says, please, YouTube, let me give the fat man some real money, I beg of you. It's all good, man. Whatever you can send in is whatever you can send in. It's all good. I appreciate it. Nick Kreuzer says, 1946 Hungarian forints are the only thing worth less than an Argentine peso. Oh. And then Kaz says, do I not want a pet goblin I could keep in a shed? We have zoning requirements here. I would probably need permits to handle him as livestock. So no, I do not want that on my property. That's a lot to deal with. Real quick, C3 metal thingies for $2. Thank you. Says my 2026 log cow is going to be quarter pounder. I can see that. I can see that as a viable log cow thing here. Malcolm Combs for $2 says, I hope Patrick wins for the second Jackie saga. And speaking of Patrick, we got to get caught up on his lawsuit with the Milwaukee police. I still think the police did some wrong. I think they did a lot wrong in the way they handled it, but it's tough because Patrick's a scumbag, but it's like the police were really wrong in how they handled it, and I think they did abuse the civil rights a little bit. So it's a tough one, chat, but that's what principles are all about. Johan says, did you hear about his dentist and his wife that got whacked in Columbus? Wild stuff. No, I did not. Ooh. Oh, no, that's not good. C3 Metal Thingies has been a member for 18 months. Thank you. Thank you for that support. Starts off the letter N. I don't know what that means. And then Adam Nash says, when are you going to start a daycare and quit YouTube? And the finest of Somalian child rearing traditions, chat. Yes. John Coleman says for $2, for some reason, Pirate Tomsky for £2 sterling. Says G for some reason. Mystery Sniper, who's been here for 25 months. Thank you for being here that long. I appreciate it. He also says G. I don't know. Pirate Tomsky for £2 sterling. And some of you might say, why not the King Sterling? I believe Tomsky hails from a part of the British Isles that is not a fan of the monarchy or the crown. So, and also, who's really a fan of King Charles anyway? For £2 sterling, says E. Let's see here. Then Pyrotomsky for £5 more sterling. It says if Russell has a glob of spit leaking from one side of his face, do you think he walks in circles for hours, Sean? He's all thrown off. It's like that footage of the Russian T-72 just like going in a circle out in Ukraine after the crew got killed. Yeah. He does a death spiral. He just it's like a torpedo when the gyros get locked out. It's a circle runner till it breaks free. Nico says it do be like that, Mr. Martin. Yes, it does. It do be like that. Nero says, how dare you stand where he stood? Yes. Yes. Nernad says, yes. He is the strongest of all in OG of Greece. Yes. 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 They truly, the bravest of the warriors out there. Truly the bravest. That is really what's important there. So let's catch back up to where we're going. Do I lose a Wordle? Yeah, at times I do. At times I do. Yes, did I see that Cargill was hanging out with Cody Wilson? Yeah. It's a little ridiculous. Just a little ridiculous. Nero says, whatever happened to Matt's IP lawsuit? It's still going. Actually, I don't. Hold on here. Let's pull up a court listener. We'll check that real quick. Let's see here. La Rosière v. Wilson. Some talk of Alexander and some of Hercules, of Hector and Lysander. Oh, wow. This is weird. There is, huh. So there's a new judge. I got to talk to Matt because some stuff's happened here. And Cody Wilson tried to file an injunction against the defendants, but yeah, nothing else has happened here. Nothing else has happened. Yeah, there's nothing new. There's nothing new. So, I'm going to have to reach out to Matt and see if there's any good updates on that. So, nothing new with that, chat. And nothing new with the Afro Man loss. I know a lot of people are asking about that as well. Yes, what a cliffhanger, yes. Then Spud Gun for £2 sterling. But in his case, with the brave British flag, the King Sterling. For £2 says R. Yes, the British Grenadiers, yes. All right, let's keep going, chat. We're not done. We're not out of the woods yet. Russell Greer, right before Christmas, gets all upset about everything getting noticed. Russell, that's the one thing you say about Russell Greer. He's a big anti-noticer. He doesn't like notice. He doesn't like notice. Yes. So the response to the notice of supplemental authority. So he respectfully responds to the notice of supplemental authority. It states as follows. The submission does not establish willful misconduct or bad faith. Instead, it instead relies on an out-of-context statement. How is it out of context? The entire statement is introduced. It is not out of context. Literally, the entire thing was included. Literally, the entire document. Not only that, all 11 pages, including all the crap you wrote, was included, Russell. It was all included, man. I don't know how you, the entire thing here was included, Russell. I don't understand. But it's all there. From litigation and recast a reasonable good faith interpretation of the court's orders as intentional defiance. No, it's just, we're not recasting it. It's what it is. At the time relevant to the motion, this court stayed discovery so that plaintiff could serve John Doe defendants. That's not what it was. Plaintiffs understood reasonably in good faith that limited subpoenas directed solely towards them were permitted. He did not believe such limited subpoenas violated this. God, I am glad I've never said that before on the record. Subpoenas. Woo! Wow. Oh. Oh no. Did I miss something here? Did somebody say something about what about the English flag? Did I say British flag? I'm sorry. Yes. It's the English flag. Flag of England. Did I say something else? I don't know. If I did, I'm sorry. But he says, rather, the plaintiff understood it to be necessary to find and serve the John Does. Okay, well, plaintiff did not act in knowing disregard of the court order. Plaintiff thought the court order allowed service. It looks like a little weirdness if you can't figure this out, Russell, and you're trained. Yes, Russell Greer makes me think of penises. I guess. Defendant's reliance on a statement made in a separate litigation does not alter this analysis. It can. You don't get to do this, Russell. You don't get to your statements are not little walled off little worlds where there's no interaction. Like, there can be notice of things. You can't do this. So, plaintiff's later description of attempted service-related subpoenas does not constitute an admission of willful violation of the court's orders, nor does it negate the good faith understanding. Well, once again. Yes, you called it the British flag. I'm British by citizenship, English by the grace of God. Okay, and yes, here we go. So, I am very English, and I will not accept the besmirching of the English flag by an uppity bloody Mick. Well, also part WAP, too, but yes. So, bloody Italians! As well as Mick. Yes, he was confused because he was at his meeting for the hookers. He couldn't overhear the talk going on. So again, plaintiff thought to stay so that John Does could be served. The only way to serve them was through a subpoena. That's the only way you can serve a witness anyway. Plaintiff's disclosure of paralegal training also does not raise a claim of willful misconduct. It does. Plaintiff's not an attorney, did not claim to be one, and reasonably relied on the distinction commonly recognized in John Doe internet cases between regular discovery and limited efforts to identify anonymous defendants. No, Russell. No, not for you, buddy. Plaintiffs cannot show a clear, unambiguous violation of a court order, knowing or reckless intent, or prejudicing warning sanctions. The motion and supplemental arguments should be denied. Signed, Russell Greer. Russell Greer. Russell Greer. Russell Greer. There. So there you go, Russell. That's not going to work. This is all cope. Right here. This is just Copenhagen. And the finest traditions from Chris Ledoux. It's Copenhagen. Russell then filed another motion right before Christmas regarding the motion to disqualify. Russell's like, it's true, support it. He's like, it's true. And just give it up, Russell. You're not going to get him disqualified. In fact, I do think at this point, you're probably cruising for, and you probably should get sanctioned for more wrongful conduct. At some point, you need to be punished. And I really hope the court takes that into consideration and punishes you for this nonsense, because this really is becoming nonsense. Also, chat, notice my hair is nice and flowery today. I cut my hair, did. After my shower getting, so I gotta wash all the little itchies out of my hair. But yeah, it gets all fluffy. But yes, the hair's done. Eric is saying, does Russ use AI to file this stuff? Yes. Yes. He's using AI. The AI formatting, you can tell, and it won't format properly. But yes, he's using AI to string stuff together. It's at least written better than he can. And notice, Russell Greer is avoiding problems out of these lawsuits or these motions. And what's he doing here? Notice you're not seeing citations to court cases with these. And I think Russell's doing that intentionally, because that way he doesn't have to worry about filing a errant cite or something that will get him in trouble. Because we've seen that, and guys, we talked about them before, and we might have to do a show again soon, because there's still more and more, and it's funny. Remember, these boomer attorneys, it's boomer attorneys that are using ChatGPT to cite things. It's not millennials and it's not Zoomers. It's boomers and like late Gen Xers and boomer attorneys who are using ChatGPT, who are using Grok, and they're using AI setups to hallucinate bullshit cases. Russell doesn't cite cases here, and he's smart not to do it, because that way he can't get held responsible for it, because he will get killed if he tries that by the court. They will burn him down. And you can see in this other case here, like he is trying to avoid that, but now we're getting to, for Russell, he finally is introducing citations. So Russell is opposing the he's replying in response to the motion to disqualify. Then they say that the IFP fraud narrative is legally baseless. I don't know about that, Russell. I don't know about that. Let me see here. Well, David, there's one thing, if you like cite, like, it's not wrong for attorneys to cite stuff and kind of like, well, here's what it says. And it's like, you only read one sentence, so you're technically not breaking the rules. But it makes you look bad in front of a court. So that's not the problem. But these entirely manufactured cases with manufactured opinions, like everything about it's made up. Those are the big problems here. Hold on one second, chat. So that's the difference here. So, and they point out the Supreme Court has long held that a litigant need not to be destitute to qualify for IFP, and that's correct. And that is from a 1948 case. And the standard is whether the filing fee would impose a hardship under the litigant's circumstances, not whether he's got zero income or assets. Thousands of litigants are granted IFP every year under the standard. And we actually talked about this last night, you guys. John Roberts did a year-end report of the judiciary, of the federal judiciary. Let me see if I can find it real quick. Yeah, here we go. It's very interesting. It's very interesting, you guys, if you've never seen this before. This is the year-end report of the federal judiciary. It's a lot of babbling from John Roberts at the beginning. I don't really care about. It's the workload of the Supreme Court. I don't care about that. Blah, blah, blah. Oh, it's so hard being on the Supreme Court. And We heard 70 cases. It was so hard. Yeah, it's the big pun defense. And it's so hard. Cheer. That's what the Supreme Court does. It's so hard being us. Well, nobody cares. Now, they point out, though, in 2024, they heard 3,800 cases that were filed. Not heard, but that got filed. The number of cases that were IFP were 2,527 in 2024. So think about that, chat. That means there were only 1,329 paid filings in 2024. Think about those. Most of the people filing in the Supreme Court are yahoos filing IFP pro se. So it's a very revealing thing. Only like 30% of the people coming to Supreme Court are actually paying for it. Now, when they talk about the other federal courts of appeals here, there are all kinds of things that are done. They talk about, ultimately, there are 39,000, almost 800 fiscal year. And then from 2024, it would increase to 41,800 in fiscal year 2025. Remember, the courts, besides the Supreme Court, operate on different fiscal years. It operates in different terms. But it's very interesting when you look at that, isn't it, guys? Some of these things here, look at all this. They say appeals by pro se litigants, which amounted to half the filings, were 20,800. Think about all that stuff there. Prisoner petitions, though, were 20% of all appeals court filings. And 88% of prisoner petitions were pro se. And a lot of these guys will be filing, they're appealing their federal habeas stuff. So they sought habeas at the district court level. They lost. They're now appealing up to whatever court of appeals they're in. But they're just saying that for 12% of them, they had an attorney or somebody working with them. They say in the federal district courts, chat, 303,000 civil cases in 2025. And it says, in the ongoing earplug products liability multi-district litigation, I think that's the 3M lawsuit for soldiers. 15 cases were filed, down from the 23,000 the previous year. This multi-district litigation was the largest in history, dominated filings since 2020. And all other civil filings increased to 303,548. Notice that. That is so much stuff. So much stuff. And it just gives you a basic look, guys. It gives you a basic look of what's going on. So there you go. There you go. It's something here to take a look at. It's a lot of paper to recycle, yeah. It's a lot of bandwidth. But it's very interesting, the bankruptcy courts. This makes me kind of worried about the economic health of the United States, though. In 2025 fiscal year, 557,000 bankruptcy dockets were filed. They docketed new filings. New filings were docketed to the tune of 557,000. Yeah. Oh. That's a lot. That's a lot, guys. That's a lot. Just think about that. Like, how screwed are we? 30% of those were Jackie Singh. But yeah, look at this. The bankruptcy filings by nature of debt, fiscal year 2025, Chapter 7, 344,000, and it goes down. And remember, there are other chapters, but 7, 13, and 11 are the common ones, but there are a lot of other chapter bankruptcy filings. And then, there were, if you weren't aware, there were 119,000 people under post-conviction supervision. And guys, remember, that's what they call supervised release and federal probation. They call it post-conviction supervision. And they say of that number, 107 were serving terms of supervised release. And then it just gives you all the information that was broken down in this. But it tells you how many people file IFP. It's a lot of people file IFP. So this is no joke. It's pretty serious. It's a big freaking deal. It's a big freaking deal. Hold on, chat. There we go. I had a massive freaking eye booger. Jeez. Since the time Russell sought IFP status in this case back in 2020, he was facing once again, I was relocating. I had basic costs. He concluded that paying the $400 fee would impose a hardship. And he says, critically, no order by the magistrate required Russell to repay the filing fee after it was accepted. The IFP issue was untouched 4 years before Hardin came on because Hardin decided to attack it. More importantly, most importantly, the plaintiff paid the filing fee. If you lied, it's not important. That doesn't cover it up, Russell. It doesn't cover that up. Doesn't cover it up. You still got to deal with it, Russell. So to convert this determination into fraud is unsupported by law and contradicted by the record. No, it's very much supported by the record, Russell. You defrauded the court here with this nonsense. You were 100% committed fraud. Once again, another orphan, don't do this. Just control enter, like make sure it fixes it. Defendant's fixation on IFP is extraneous and improper. Rather than litigating the merits of this case, well, Russell, you've already done that. You have no witnesses to present. You have no case, including fair use, copyright scope, or statutory defenses. Well, their discovery's not over. Defense counsel is doing what is serial collateral attacks. He just can't be stopped, chat. The unrelated claims include the repeated filing of his finances, the weaponized unrelated litigation, the rhetorical escalation, suggesting criminal or ethical misconduct. And this pattern has extended and prolonged the case. Yeah, no, that's not exactly it. Yes. Yes. You accused me of fraud? It is you who committed fraud, Mr. Hardin. Like, no, it didn't. This case, which soon enters its 6th year. Whose fault is that, Russell? Whose fault is that we're on year number 6 coming up? Whose fault? I feel like Skullface in Metal Gear. Who? Who is behind this stalling? Who? You know, who is behind this betrayal? Oh, no. That conduct is not zealous advocacy. It's a litigation strategy untethered from the merits. Okay, yes, I expect you to get it, Kaz. Thank you. The motion disqualifies not an attempt to avoid scrutiny or investigation, as the defendant suggests. It is a response to Hardin's repeated decision to pursue inflammatory side campaigns instead of litigating the case in good faith. No, Matthew Hardin's just a completionist, Russell. He's completing all the side quests in addition to the main game. He's going to get 100% completion on this. He's playing U-boat and he's securing even the Argentinian escape, which is really fucking hard to do at the end because everybody's hunting you. Or it's like completing like Operation Drumbeat. That's a really tough one. Complete all 3 phases of Operation Drumbeat. Woo, buddy. That's a tough game. Tough mode. He's completing all the side quests. Hardin's insistent on framing a waived filing fee as some sort of giant elaborate fraud. Well, it's not giant, but it is very elaborate, Russell. Demonstrates a departure from appropriate advocacy. I mean, no, if I can figure out a way to kill the case without, you remember, if you can win without firing a shot, you do it. It raises concerns about Matthew Hardin's objectivity. He's biased. He's representing a party, Russell. Proportionality of what? and compliance with professional norms. He has not done anything wrong. When counsel abandons merit-based litigation in favor of personal and financial attacks, disqualification is an appropriate remedy to protect the integrity of the proceedings. You already said you didn't want that. You wanted him just admonished and reprimanded. So which ones of these are here, Russell? So he points out, you're playing right into my hands, Mr. Harden. Which, how? And notice, this, he's like, your opposition confirms rather than defeats my motion. You know, but I'm playing the trap card. It's like, you have 3 sentences for this, like, massive mic drop. But I guess we'll read it. The defendant's opposition does not rebut the specific conduct. Instead, it relies on false and conclusory accusations. What are the conclusory accusations, Russell? Because this itself is a conclusory accusation. Your claim of conclusory accusation. Oh my God, it did snow more. Jesus. Conclusory accusations is a conclusory accusation. What more do you have, Russell? Please provide sources. Citations are needed. This doesn't work. This doesn't work, Russell. It doesn't work. So anyways, they should reject the unfound fraud narrative. Is it really unfounded? And grant the motion is qualified. You cite nothing here, Russell. You cite nothing at all. Once again, signed Russell Greer. Russell Greer! So, yes, the citation. He's an idiot! And he cites nothing else. Yes, Kaitan is like, but it's you who needs to provide citations. I'm just waiting for, I can't wait till there's court filings like, Your Honor, somebody is being an A-log. Or I can't wait for a deposition at some point where somebody's like, goddamn A-logs. It's like, what did you mean by that, sir? Well, when I'm talking about the goddamn A-logs. You ever heard of Anthony Licano? Oh. MLS, David, how you doing? My favorite person, Russell Greer. Yeah, it's easy. It's easy stuff to put together. It's easy content. It's easy content. That's why. Citations upon citations. Interlinked. Oh. With as Cooper says, yes. Hello, stalker child. So Matthew Harden shows up one more time here before the end of the year, just with a little more of a smack to Russell's, just a little bit of a mushroom slap right to Russell's cheeks. You know, Matthew Harden's working during the holidays. You know, just like Bob Cratchit being forced to work. You know, just being forced to work by the evil Russell Scrooge, who keeps forcing him to do things. Kitchen Knife Rescue, are we talking about Cessnas yet? No. All right. So anyways, here we go. It's a motion in support of the motion to complete the record. No, it's just like all these responses back and forth, back and forth, back and forth. And this goes back to, remember, Russell Greer had submitted a portion of his court filings, his book, chapter 1, but he had also sent in like the table of contents and all that goobery stuff in his book about how I sued Taylor Swift and became known as crazy, litigious, and wacky and all of that and frivolous. And Russell cited everything in the book. He cited all the table of contents. All the other stuff is in the book there. And, you know, you're just like, why would you do that? Why would you do that? And, you know, Russell went ahead and did it because he's just a complete goober. He's a complete goober. Like why would you do this, Russell? I don't know. I don't know why he would do it. But he did. And he filed all kinds of nonsense for some reason. For some reason. Which I still don't understand. And let me see here. But as Russell's, he put the whole first chapter of the book out there. And it was just really the most schizo posting of it ever. And it's from here where Russell includes his stuff. And you're just like, I remember reading this. If you guys have never read Russell's book, which it's available all over the internet now, but if you want to read the first chapter, you could come here to filing number 415, and you're just like, buddy, why did you do this? Because we get through all of it, and he talks about when Natalie Banks wrote, but then Russell Greer's entire thing, where he signed his whole book, copyright 2017 by Russell Greer. And yes, he has the email address of whyisuedtaylorswift@gmail.com. And guys, he sued Taylor Swift multiple times. And he says foreshadowing. He says, either I'm dead right or I'm crazy. And that is Jefferson Smith, and Mr. Smith goes to Washington. Although, remember, and then that's the thing, Russell, what happened to Jefferson Smith at the end of his big filibuster? He dies and the band played on. But as Russell shows, he goes through here. This is all of Russell's, notice, and he cites the entire book, the entire chapters of it. And yes, this is Russell Greer's, this is what he thinks he looks like. Russell thinks he's, this is me. I'm Russell Greer. This is what he thinks he is. This is it. And this is what he also thinks he looks like. And this is also what he thinks he looks like. Although, to be fair, if any women did see him, I'm sure that if women have their chance, they would want to defend themselves against Russell. And then they'd want to attack him because he does like to attack women. So, this right here, Mama Monster based. Based. As he falls. It just gets nuked. Oh, no. You guys are pretty sure that's Adam Fredden? Yeah. This does kind of look like Super Villains Anonymous, kind of like this part up here a little bit. You're like, I like it, though. Yeah, she blew up his story. He got nuked. Yes, Kiwi Farms is the entire book. That's what Natalie did to him. That's what a lot of women have done to him. Except for the one he attacked, sounds like. So. But we're going to get back to this here. They point out the opposition at 419 offers 3 reasons why Russell Greer should not be required to submit the entire writing rather than a mere portion. First, Russell Greer states his portion of the writing isn't misleading, which Russell Greer's is a necessary prerequisite. And he says, second, Russell Greer argues the defendant's evidentiary entitlement somehow guts copyright law. Then they say, third, Russell Greer argues that forcing him to publish the entirety would cause harm. And it says, as far as the arguments go, Russell is incorrect to state that they don't identify any sentence. It becomes misleading. And they point out that Russell Greer first argued to his own exhibit that he did not advocate violence or harassment. But Russell Greer himself previously admitted the very writings contained evidence that various judges saw it differently and issued protective orders. Yes. It's all an exhibit. It's all needs to be admitted. Because this would be used to impeach Russell at testimony. And Russell Greer himself opened the door to admitting the full contents when he filed only an excerpt. And they say as to his second argument, and this is the other part too, it doesn't have to be just because it's misleading, but Rule 106, the rule of completeness, is that in fairness, it ought to be considered at the same time the remainder. And that's all you're doing. It's context. Yes, don't copy his floppy. Thank you, mediocrities. It says, Greer's not shown any tension at all between the rules of evidence and the substantive proportions of copyright law, much less whether later should prevail. And it says, Greer fundamentally misunderstands his position. The defendants have argued that if they reproduce or encourage the reproduction of any copyright material, they would have done so as part of fair use commentary. They say without limitation, the defense and others have commented on the fact that Greer is a legend in his own mind. That is so brutal by Matthew Hardin. But that Mr. Greer is violent and abusive to women, as documented in his own autobiographical work. Greer sees this as defendants arguing the infringement is justified because someone believes the author is bad or dangerous. But that is not at all the argument. No infringement can possibly have occurred if there is legitimate commentary upon the book. Even if that commentary is motivated, it amplifies a dislike for Greer or a belief he's violent, vexatious, and or spiteful. Well, he's already acknowledged he's vexatious. And yeah, he admits in his writing he's violent and indeed spiteful. So he acknowledges it. He acknowledges all of it. As to his third argument that publishing the entire book would cause real harm, Greer is again mistaken. Factually, Greer's entire writing has been available online for the duration of litigation because Greer has made the intentional choice not to request that Google remove the book from the internet. And that's exactly true. Remember, Russell Greer never sued Google to take it down. Why? Because Google would tell him to go fuck himself, and Greer would lose. And Greer's kind of doing the opposite of Acer Thorn. When Acer Thorn sues Google or YouTube, those lawyers come in and save the day and kill the case off for everybody. And Russell Greer appears to be smart enough to know he doesn't want that smoke. There's a reason why he didn't do it. And they also point out, yes, he is spiteful and spiteful. Yes. And they point out the court acknowledges that Greer never requested Google to take down the book, and that is to his own detriment. Yes. There is no harm at all if Greer's book is also available on Pacer due to Greer's own decision to file an excerpt of that book as an exhibit. Because Greer's book has always been and apparently will always be available due to his online choices. Also, he already said he's lost the market for it, so it's worthless now. So what more can it do? Also, the court can seal evidence rather than file it publicly on Pacer, which is totally true. But Greer doesn't seek to file evidence under seal. Instead, he seeks to keep this court focused entirely on his own carefully curated excerpt, rather than allowing defendants to make arguments based on the entirety of the writings. So what do they want? They want the entire thing to be considered alongside Greer's excerpt. And they say defendants don't suggest that Russ can meet the standard for sealing, but note only that he has not made the attempt. If Greer believes his book should be filed under seal, he should file the appropriate motions, to which defendants will respond in their ordinary course. And that's fine. Just saying, we don't know what's going to happen, but we'll argue later. Signed by Matthew D. Hardin. Puts the D in hardship. David says he could have DMCA'd it and it would have been done in minutes. I probably, but at this point now, as he wants to sue, he needs to include Google, and Google should have been included as a necessary party. But going back to Scored is kind of fucking that up. Scored has kind of fucked this up. So, yeah. So that is the that is them. And we have a couple more things here. EDW Raptor for $5 says happy birthday, Sean. It is not my birthday. Not till August. Not there yet. Oh, but yes, chat, that is all caught up on Russell Greer. We got his new lawsuit in, and like I said, I'm not going to look at it. I just think it's hilarious. But it says a lot when you can't find 5 people in whatever county you're in that want to support your little whorehouse initiative. It's like, buddy, Russell, like, and I say this with all honesty and sincerity. I don't know that area of the country, but if it's like at all where I grew up, and I grew up like I didn't grow up in like the most rural place in the world, but I grew up in a very rural area. If people don't like you and you're causing problems like this, you need to be very, 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 very careful. Like, because especially in the desert, man, like people won't be afraid to leave you out in the desert. I mean, it's one thing if you try to make somebody disappear in the woods of Ohio. That's hard, but like as they say at casino, man, they ain't got no problem putting people out in the desert. So just be careful you're gonna piss off the wrong people. Like that's me actually being sincere to you. Like, be careful, Russell. If nobody wants to help you, man, like that's a warning sign. That's a warning sign. Maybe you need to go international with your, your hoe business. Somali Daycare says, I have a Marcy Darcy haircut. It's evil. You're so mean. Uh Jay Jay Bemke says this is all it's all this fake thugging that is getting them is killed, Sean. I know. I know. Gotta be real in these streets. Gotta be real in these streets. David says yes. Earlier citations said the exact opposite of what Greer is claiming. They're relevant but wrong. That's why Greer hasn't gotten in trouble. But Russell has to be very, 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 very careful. So that's why I think he's avoiding using ChatGPT for that stuff. Then, real quick, another for 5 subs. Thank you, another. Big frickin' support tonight, chat. Let's see here. What else we got? We've got EDW for 5 subs. Thank you guys for your support. Thank you for your support, your generosity. And guys, if you got a sub, please tell them thank you. The Amateur Iconoclast for 1 sub. Let's freaking go, guys. Let's go. Winter Soldier says the honorable debtor stuff is BS. Yeah, well, that's what they call it. That's what they call it. EDW after 5 more subs. Let's go, guys. Hell yeah. Hit the new year running. Make these greens. Just know. Like, this is what we do. And these grays will know that this is our land. It's just like in Red Dawn. Why are we doing this? Because we live here. Because we live here. Then Radcon Hazard says technically could pay the court to get the Greer book. Well, if it gets filed under seal, no. What? Theoretically, yes. But it's out there in other forms, so you can get it. Like as he said, he's already lost the copyright. It's like not lost the copyright, but it's already worthless and garbage. So, at this point, yeah. So there we go. Let's see here. Yes, try that in a small town. No, I'm serious though, man. He needs to be careful. Like, it sounds like the whole Winnemucca thing. Like, they told him, don't come. Like, the people in the city council we talked to were like, buddy, you shouldn't be here. Don't come out here. This is not going to go well. The guys warned him, and he still showed up. And then this Roger Baylock guy had to show up and say, like, who the hell is this guy trying to eminent domain my land? I didn't even know about it. Like, that'll piss off a lot of people. And that is like fucking with somebody's property and fucking with their land, man. Oh, that is never a good idea. I don't care who you are and where you live. Don't fuck with somebody's property like that. Like, it's one thing if it's like their personal property like this. But like their real estate, like their real property, like their land. No, you don't ever want to mess with that. You don't ever want to mess with that. So got to be careful. Got to be careful with that. You're wishing the pit bosses would have given him a deluxe heave ho. Well, no, I don't. I don't wish anything bad to happen to Russell like that. But I mean, he needs to be careful that it hasn't happened to him. Like, there's nothing wrong with me saying, like, you are fucking around in things that are really dangerous right now. People have money. tied up in land and things like that. Nobody likes that getting screwed around with. Be very careful. That can, oh man. Whew, I would not want to be in that situation where people think you're trying to steal their land, dude. I'll tell you that much. Yeah, you could end up at the train station. Like I said, I don't want anything. I don't want him to get hurt. But yeah, this is not easy stuff. It's dangerous stuff. Kay says, "Can we play Jackbox tonight?" No, we will do that tomorrow night. We'll do that tomorrow night. It's already like 10:50, so I'm not sure what we're gonna do here, but we'll do something. What did you miss? You missed everything, Roscoe. I think it's because the LDS, his mentality is people won't do anything bad or harmful to him. I mean, I guess I hope nothing bad happens to him. I don't want him to get hurt. Like, it's fun to laugh at all this stuff, but I don't want people to die. I'm just saying you have to be careful. Like, you start screwing with people's like real livelihoods and their property and their birthright. That's absolutely dangerous. Absolutely dangerous. I would not want to do that. I presume at some point you're going to cover the Mickey Stein's motion to disqualify the judge. Yes. I will. We're probably going to do that probably like Tuesday. We'll get into that. Did I hit the P.O. box? Oh, shit. No, I knew I forgot something. I went out, got my hair cut, picked up stuff for 2.0. Completely forgot about it. So, no, I can go get it tomorrow. So, no, my apologies. I completely forgot about that. The idea of Russell Greer ending up disposed of in a Nevada desert like his porn star idols is fitting. Well, yeah, I mean, like, I understand people want that, but it's still, I don't like to see people get hurt. Yes, in an alternate timeline, he's in jail for harassing these women. And that's the interesting thing. He has not gone to jail for this conduct, which I'm very surprised at, which is very weird. Don't mess with DSP's digital property. In my area, the LDS is on par with Scientology. Well, that's a little different where you are. I mean, maybe in Utah, but here the Mormons are okay. They stay away. It was alone. Let's see here. The LDS are better than Jehovah's. Well, yeah, 100. Yes, a lot of people are better than Jehovah's Witnesses. Holy cow, those guys are crazy. Those guys are interesting to deal with. Let me tell you what. You hate both, but they're less shitty. Well, yeah, the LDS are a lot better to deal with than Jehovah's Witnesses. Yeah, and that's the thing. He has the lolcow immunity. I'm not joking, guys. Like, it's a thing. The lolcows have a unique, innate ability to avoid everybody's already seen this and knows it. They have a unique ability to avoid, legal punishment and consequences for the most part. Both are heretics, 100%. They're both heretics, so. They're all swole from doing Jehovah's Fitness. Missouri Battleflag says the founder of Jehovah's Witnesses is buried under a miniature pyramid. So, like, they buried him and they took, like, a little pyramid and went, like, boop. Like, is that how they did it? Because getting buried under a miniature thing would be pretty easy. Or did they build a pyramid over the top of him? That's kind of the I'm more curious about. LDS created the poop hole loophole. I thought LDS created the soaking loophole where you lay there on top of her and then everybody jumps on the bed and you move around. Oh. The jump humping, yes. They build a pyramid over the top. It's not that miniature. Oh, okay. Well, I didn't know that. Hold on here. Founder pyramid. Okay, refers to the Great Pyramid of Keys, a connection to Charles Taze Russell. Okay, so there's a pyramid. Oh, I mean, like, yeah, it's kind of a serious pyramid. Whoa. That totally does not look like. Yeah. Okay, hold on here. Yeah, where is this picture of it? Okay, so it's like a whole like this is a real thing. No shit. No shit. I'm gonna bring it up, guys. Here we go. So this is like he has a real pyramid over his grave. Huh. That's interesting. Okay, and he has his yeah, okay. But this is interesting here because this is the whole stuff here. All right, chat. Uh-oh. Israel restored. I don't know if I like this. Oh, wow. Okay. Well, this is just all the weirdness of the this is the thing. I've read this before about the Jehovah's Witnesses. This is pretty interesting actually how they became to like where they are today. They had a bunch of schisms. And they have this weird thing now where there's like you could Google some of these people, like free Bible students, associated Bible students, the Layman's Home missionary movement. There's some weird little religious sects out there. And then there's Jehovah's Witnesses. The pyramid is no longer there. Oh no. Oh no. It's broken. He was obsessed with the measurements of the pyramid. Was he a freaking mason? That sounds weird. Yes, it's too small for a Bass Pro Shop. Yes, that's true. Smalley Daycare says soaking was very much a thing in the mid-90s. Okay. Let's see here. The BKS says when Armageddon comes, you know which houses have the food. The LDS are ultimate preppers. Yeah, and they'll use guns to protect all that food. Like, that's the thing. If people have preps, they usually have guns, and they'll kill you to protect their preps. So just showing up at the door empty-handed ain't gonna go well for you. That's just common thought there. Eisenhower's mother was part of Jehovah's Witnesses. Really? Really? Yes. Keep your rifle by your side because they'll look high and they'll look low. And they'll look everywhere they go. But when those sinners find us, we won't hide. And while they may come loud and they may come fast, we'll shoot first and we can last. Just keep your rifle by your side. So, all right, guys, that's it for us tonight. We're all caught up. And I think I've caught everything. Up here. Perfect. We're all done, chat. So, is this a preview of my wedding vows? No. No, that is not a preview of my wedding vows. We are going to get started on... We're going to work on some of this pile of shame tonight over on the model bench. I got to get some stuff done. And I'm trying to, because it's all sitting right here, I'm going to try to work on some of the stuff that's been, because I will give you an update, chat, real quick, since you're all here. We're going to talk about this real quick. The Sepp Allerberger. Oh, we're going to get to the military history thing today. We haven't talked about Destiny. Destiny we will work on next week. But the Sepp Allerberger model for bolt action has been fixed and accomplished. He is all done. I'm actually very proud of it. It's actually pretty nice. He said yes on painting. We're doing painting on the model stream. Yes. Anyways, he's got his all set up there. And I'm actually pretty happy about this. I was able to do some good layering with his umbrella piece. I don't know how well it's going to show up. But I was able to do very well. Did I print this? No. This was from EDW Raptor. This is part of the Bolt Action series. It's a little like additional sniper figure, so it looks pretty cool. Can we listen to George Lincoln Rockwell's speeches? Why would you want to listen to that homo? Like, he was gay. He was gay! He got killed by his gay lover! Do I have my second channel on Rumble or Kick? I don't have either, so... Huh. I haven't thought about that, but really... but we'll work on actually two of the things that EDW Raptor sent, which are these the little reconnaissance cars. We'll work on getting those together, and then we'll work on that, and then we'll get into the stuff that's already in the closet. I just need to get some stuff going here. He used to work on model streams on his Kick channel, and I'll probably, you know what, I'll fire that up and just do them on the Kick channel. But the Kick channel's algorithm doesn't matter, but it's the algorithm for this channel. Apparently, I didn't, it was only a fraction of things, but apparently for some people, it's saying their YouTube algorithm says that this is a model channel now or something. So whatever, I'm trying to fix it, trying to get it to be different. So that's kind of what we're dealing with. So let's see here. GLR is gay. What? Yeah, I'm pretty sure George Lincoln Rockwell was gay. I could have sworn he was. Hold on here. I could have sworn he was. I could have sworn he was gay, but if he wasn't, he looks like a homo. He shot Audie Murphy. Oh, I thought he got killed. Sheet Commando says, does Sean follow this chat? Yes, I do. Let's see here. No, he died. He got assassinated. That's not, that's actually, like, he did get murdered. He didn't die of old age. So he got killed, but he wasn't gay. Well, I wasn't sure. I could have sworn he was gay. I'm falling for Semitic propaganda, yes. He was gay enough to join Dick. All right, chat. So with that said, we are going to go over to the model channel, and we're going to work on some stuff. And get some, like I said, there's already stuff out here, so I'm just doing we're just working on it that way, just because it makes sense. Like I said, that's just, it works this way, and then we will work on getting into what's out there in the closet here pretty quick, and getting into working on J-Rock's Ferdinand, and kind of catching up on some stuff. Like I said, we got to get some more things caught up and then be done, and yeah, that'll be it. So working on that, and like I said, chat, I will see you guys this week. We'll work on some more stuff and get ready. We'll get ready for that trial that's starting. Manual raid in the model channel. I need to set that up here. I'll set that up while we're getting away here. Okay, come on. Don't want that. Hold on, I'm pulling up the thumbnail because that actually helps a lot here. Hit the thummies. Let's see here. No, that's not right. All right, chat. I will see you guys shortly. Where did that go? Oh, damn it. I hate this one, StreamYard. Okay. We'll set this for 5 minutes from now. All right. So, chat, with that said, I will see you guys soon here. And just remember, until next time, just because you did it does not mean you're guilty. Except for Russell Greer, you're guilty of a lot of things. Good night, chat, and take care. Oh, wait, come on. Outro song, play it. There we go.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that